Hello and a warm welcome to Federal Special Program Capital Beat. Supreme Court today asked the Election Commission to include Aadhaar as the 12th prescribed document for establishing the identity of a voter in special intensive revision exercise of electoral roll in poll-bound Bihar. At the moment for Bihar SIR, there are 11 prescribed documents which electors have to submit with their enumeration forms. A bench of Justices Suryakant and Joy Malia Bagchi, however, clarified that Aadhaar will not be a proof of citizenship and the Commission can ascertain the genuineness of Aadhaar card number submitted by an elector for inclusion in the electoral roll. Now, observing nobody wants the EC to include illegal immigrants in the electoral roll, the bench said that it should be clear that only genuine citizens will be allowed to vote and those claiming to be genuine on the basis of forged documents will be excluded from the electoral roll. Now, what has the bench asked now? The very important things. The bench asked the poll panel to issue necessary directions during the course of the day for acceptance of Aadhaar as a document for proof of identity. Then the top court has also sought EC's explanation on show cause notices it issued to the poll officers for not accepting Aadhaar card from the voters. But the big question is that will the Election Commission of India obey the orders of the Supreme Court, given the fact that they have made violations earlier? There have been three orders earlier, but on the ground, violations have been rampant. So this is what we are going to try and discuss, and we'll also understand what this Aadhaar as the 12th document will mean for the SIR case. Joining me this evening is Neha Rathi, who's a Supreme Court lawyer. She's the advocate on record, and also the lawyer for Mahua Moitra, who's also one of the petitioners in the SIR case. Thank you so much, Neha, for joining. We have Dr. Pyari Lal Garg, election data scientist of the country. Dr. Garg, thank you so much. And I'll begin with Neha Rathi. Neha, you were in the courtroom when this hearing was on. What does it really mean? Can you explain that Aadhaar will now be the 12th document which is admissible in the SIR case?
See, this is a significant order and also slight extension of the previous orders, which were, of course, as we know, were not followed fully by the Election Commission. Earlier, also, the Supreme Court had said about accepting Aadhaar, but it was in a way limited to aggrieved people. Now, what did they mean by aggrieved people? Was that people whose names have stood are deleted already. That is, out of those 65 lakh, out of the total voters, approximately 8 crore. So for them, they said for claims and objection hearing, they will accept Aadhaar. However, on the ground, we got to know that instructions had been given to BLOs still not to accept Aadhaar as a standalone document. The impact of this accepting Aadhaar, this direction that Aadhaar should be accepted as the 12th document, means that in their enumeration form itself, where they had mentioned these 11 documents, now Aadhaar, giving Aadhaar would ensure that a person's enumeration form has fully been accepted. Now enumeration form period though is over. So now the claims and objection period, may if somebody gives an Aadhaar, so that itself, they will now not insist on those 11 documents. Plus, another repercussion is that a positive one is also with regard to the 7.24 crore voters whose names are in the draft list and many of whom, more than 3 lakh, have been issued notices. So notices की hearing अलग होएगी, उसमें भी अगर वो आधार देते हैं तो उसको एक्सेप्ट किया जाएगा, 11 बाकी डॉक्यूमेंट्स पे इंसिस्टेंस नहीं करी जाएगी. ये सुप्रीम कोर्ट ने कैटेगोरिकली आज बोला है. तो ये पुराने वाला ऑर्डर जो कि लिमिटेड था डिलीटेड वोटर्स पे, उससे देयर इज एन एक्सटेंशन टू दैट.
Neha, the big question is that there have been violations earlier also. Do you think that the Supreme Court orders will be obeyed by the Election Commission of India? Because given the fact that Aadhaar was supposed to be accepted, but even then the BLOs on the ground, of which there was a proof today in the court where Mr. Sibal and Mr. Singh said that there was enough proof to show that those BLOs who accepted the Aadhaar card, they were given show cause notices and they were translated copies of the show cause notices today. So what does that mean? And are you fully convinced that Election Commission given so many transgressions they have made in the past, will they actually obey this order also?
See, today also we had taken to court notices which were very categorical. Show cause notices issued to BLOs in.
Dr. Garg, just please allow me to interrupt you. Dr. Garg, can you just mute yourself? I think there's some sound coming from your end. So while Neha speaks, and no, I'm
Yes.
saying just mute yourself. Dr. Garg, can you just mute your frame? Yes, if you can just mute, then there'll be no sound there. Yeah, now it's fine. Okay, Neha,
So
go ahead,
today
please.
we showed to the court show cause notices which had been issued by the EROs of one district, for example, one constituency, Sitamarhi, to the BLOs saying that you have been accepting documents uh, which are outside of the 11 documents as mentioned in the enumeration form, that is Annexure D, they call it. And therefore, you must explain why you have accepted these documents and why should any kind of disciplinary proceeding should not be taken against you. We took this to the court, we showed it to the court, though that notice does not mention that why have you accepted Aadhaar. But the insistence on 11 documents was, categorically there, which Justice Bagchi also pointed out after seeing that why are you mentioning this 11 when we have already ordered for this? So that became a little bit, that changed the mood of the court, because that is clear cut indication that this is not being followed everywhere. Now, whether or not election commission said that no, this is not happening, but they were a little bit surprised because they did not have anything to say. We had information also that clear directions had been given to BLOs other than these show cause notices not to accept. So this was absolute contempt of the court, which we pointed it out. This is willful disobedience, non-compliance of multiple orders. Now, whether or not election commission, we will be filing a contempt, of course. Now, if they do not abide by this, if they do not accept 12 even now, which can, yes, there is a possibility,
No, but
but
Neha,
then.
there's another thing. Justice Surikant very clearly said that, SIR is an ongoing exercise. We should thrash out these issues and the legality aspect can be discussed later. Now, what is the direction this SIR case will take? When, for Justice Surikant, legality comes much later. It's almost like, that same case which we saw in the appointments of the Election Commission. The case was not dealt with. The appointment of Mr. Gyanesh Kumar happened as the chief election commissioner. So now that case will go on and on. And similarly, I think the SIR case will also meet the same fate. That okay, you deal with the immediate things and let the larger question around the legality of the SIR, let it continue for years. What does it
Yes.
mean now? What I want to understand from you is, what direction is this SIR case now taking?
See, this is in the form of an interim direction, a sort of a damage control. Of course, our challenge remains to the constitutionality and the fact that the entire process is ultra varies the act and the rules as well as their own manual. The manner, but more importantly, the order itself is unconstitutional, and we are not going to stop here. However, given the hurried timeline, there is no option but to do some kind of a damage control so that names are not deleted. So we categorically on our side, even in our note, we start with that. Even in our arguments, we have noted that we want the legality to be decided. If ultimately the court's main job is to decide the legality of something, and as you said, of course, it is very, very disappointing that the such an important case of the appointment of the CEC has not been decided, has not been given the priority it deserves. And now also, if I'm not wrong, it's listed in October. So the court needs to, take this into account, that had they decided in that initial hearing only, had they given some kind of a decision on the legality of it, it would have gone much better. However, we are not left with many alternatives, and we were forced to go into this interim prayer business because we cannot afford, the risk is too large for people to be
Yes.
disenfranchised. So
Yes.
that is how it has taken this turn. However, I'm happy we were able to, at least the court, like last two times, did not go into the direction of, a trial of political parties or, appointing these paralegals and all. We also pointed out they have not even been appointed. So that is also not being followed. So these kind of issues remain. So everything that happens when we go to the court, the
Right.
better way, of course, is that you decide the legality of it first.
Absolutely. Okay. So I'll come to Dr. Garg now. Dr. Garg, now Aadhaar will be valid as a 12th document, apart from those 11 documents which were admissible so far. Supreme Court today has given a direction to the Election Commission saying that they should issue directions to the BLOs and the poll officers who are there on the ground so that they can accept Aadhaar. Now, looking at the past incidents which have happened where violations and transgressions have happened rampantly, how hopeful are you about the election commission listening or obeying the orders of Supreme Court? And how would you look at the hearing today? How significant is this step of making Aadhaar the 12th the document in the SIR case? You'll have to unmute, sir. Yeah.
Basically, Nilu, I don't find anything coming from the Supreme Court. The Supreme Court is to decide as per law. Supreme Court is only advising, passing order, quoting the law. When the Representative of People's Act 1950, Section 3, subsection 4 says that if at all any document can be sought for, it is only the Aadhaar number. And even
Yes.
if Section 23, subsection 5 says, even if the Aadhaar number is not given, it is not provided, neither the registration can be denied of an elector nor a registered elector can be removed. No, the election commission is just advising and all that. Either the election commission should, the Supreme Court should strike down the People's Representation Act. They say it is illegal, it is unconstitutional, it is out of arrest. Well, they should implement it. What is this they are doing? Section 21 says that the revision of the electoral rolls, I'm not going into whether it is a special intensive or it is intensive revision or it is a summary revision or it is a combination of the two. The Section 21 says the revision shall be carried out as per procedure laid down, and the draft electoral rolls shall be published in accordance with the rules framed under this act. Where is that? Section 19. Section 19 says the elector has to give only two things. One, I am not less than 18 years of age on the particular date decided by the commission. And two, I am an ordinarily resident of such and such place. If my statement is wrong, I may be proceeded against. Where is that I have to provide 11 document, 12 document? The court is not working as per law. It is army of the fate. And I don't show with due regard to all the legal luminaries. And they are not raising this question. They should agitate on this issue. Whether the court is to decide like a panchayat or like the Supreme Court of the country. The enumeration form designed by the election commission on its own in violation of Rule 8 of the Electoral Registration Rule 1960. There is a preside form 4A. And in the form 4, it is not to be distributed to everybody. It is to be distributed only to the head of the family. And the head of the family is to fill all the names. And no document is to be provided. I don't know where are we fighting for, where, to my mind, it is nothing but a jingoism. The Supreme Court, with due regard to the Supreme Court, with due regard to I am a surgeon. They are surgeons who are trying to just prick, a huge abscess is there, they're trying to prick only a needle in it. They're not trying to do a surgery. So this is what the legal luminaries are doing. When in the first hearing, the Honorable Supreme Court said there is no procedure laid down. There is no question. It is not laid down under the rule. What Section 21 says it. Either they had read the old act or they had confused between 1950 and 1951. There might be something, some confusion. To my mind, I have been going to the courts for government cases and I have always won the cases. The issue is the petitioners, the applicants, they should go on hammering the legal points. They're saying, oh, my lord, there is no time. My lord, it is injustice. My lord, they are doing illegal. They are not hammering the legal points. Let the Supreme Court decide. Let the Supreme Court say, we don't agree. But the only fight should be on the legal points. They are trying to make it a panchayat rather than a court. This is my objection too.
No, but
The
this
Supreme Court.
entire, but Dr. Garg, today, if you look at the hearing, the entire case,
Yeah.
went round and round like a merry-go-round between the Aadhaar card and the citizenship issue. Justice Surikant
Niluj,
said something, then Maninder Singh and Rakesh Dwivedi said something. I think Neha
yes.
can vouch for it, what I'm saying. It just went on and on and on, round and round like a jalebi. What would you really say, Neha? I'll just take one comment from you and then come back to Dr. Garg again. Yes, Neha.
See, frankly, I absolutely agree with the Dr. Garg also, because this has been we have also, as a team of all the senior advocates, the assistant counsels, AORs, have been very, very frustrated with the court's attitude towards this huge issue. This is an issue of which can lead to huge mass disenfranchisement, and legality had to be decided. That is why 2.5 days the petitioners argued on constitutionality, why it should be set aside. Now, whether it is because of the logistical issue, because within the next day of the hearing, constitution bench had to be set up. There was no time that could be given to the election commission to effectively respond to our 2.5 day of argument. And then, of course, our rejoinder time was also not there, because they knew the next 10 to 15 days they are going to be busy with the constitution bench in court 1, the same bench. So this is how it went. We have been extremely frustrated on the last two hearings because of the direction the court was taking. Today, at least in comparison to the last two hearings, it was slightly positive because something we could get out of the court. Absolutely, the situation has been that it is like, beggars can't be choosers. If the court is right now not going into the legality business, though every time, especially Gopal Shankar Narayanan, senior advocate, we have been pressing that you decide the issue. Today also a prayer was made, and even in our note, this is a categorical prayer that please fix a date for final hearing. Now, see, after a point of time, lawyers can do only so much. So what we can get, sort of salvaging out of the situation. So that has been the attempt so far. As far as the EC is concerned, today they were on slight back foot. I felt they were not able to show to the court why Aadhaar cannot be accepted. They are saying that okay, this you make sure that, and they put it in the order also that it is not a proof of citizenship. Well, that's fine, because Form 6 is the form for inclusion. It requires two things. It's for inclusion of new voters.
No, but
Firstly,
when this
that
inclusive,
should not be applied.
no, when
Form
you were,
white
when I
form.
heard one of the lawyers saying that we can't be over inclusive. They also said this during the court
That
proceeding.
is what yes, that is what the ECI senior counsel said, that we can't be over inclusive. Absolutely, and which was rejected by the court. They said that your job has to be inclusive. You can't, and especially when this form 6 has three requirements. First, you show date of birth. It mentions you can give Aadhaar. Second, you show place of residence. It mentions you can give Aadhaar. With regard to citizenship, there is no need. There is just a declaration. So anybody all over the country other than Bihar can get their name included with just a declaration. Of course, giving a false declaration is punishable by law, and it mentions so. But when for the rest of the country and everywhere, even for a new voter, you can accept Aadhaar, then why is it that for SIR process, Aadhaar, which has the most coverage, is being left out? Of course, enumeration form is unconstitutional. Of course, everything, even this notice, we have brought it, the notices that are being issued, absolutely unconstitutional. They don't even say what discrepancy. Your guidelines, point para 3F mentioned that acknowledgement would be given, not given. Your orders not followed. There is absolute, confusion that has been created on the ground. So these issues are definitely there.
Right. Okay, so I'll come back to Dr. Garg to what you were saying. Dr. Garg, please proceed. Yes.
So if you give me 2 3 minutes, I will explain only
Yes.
one thing. One is that from the very beginning, the Supreme Court is not working as per law, to my mind. We do regard to all the things. The Supreme Court is to decide whether a law is there or not, whether it is being implemented as it is in that aspect. Supreme Court is not supposed to see initially whether it is practicable or not, and we are doing something else. Two, two, the Supreme Court has been passing orders, maybe advising. The Election Commission has been openly telling the Supreme Court, not is the question of the prestige of the Supreme Court and of the legal luminaries. Election Commission is from the very beginning saying that we are equally intelligent as you are. Election Commission in any case is an executive authority, though a constitutional authority. But the Supreme Court is an independent organ of the state out of the three. So that is the difference. The Election Commission, any no executive authority, whether constitutional or legislature or statutory, cannot equate itself with the judiciary. This is wrong. Nobody has tried to do it. Two, the law says estoppel. The principle of estoppel, the Election Commission is stopped from doing things which it has itself said. On 1st of May 225, Ganesh Kumar says, we will ourselves check, and it is provided under the Act also. They are empowered to collect all the birth registers or the registers of the school enrollment, and then they can check their own data. And he said, we will take it online, we will check ourselves so that the procedure is expedited. At that time, there was no SIR. Now he is working out. He is stopped from doing it. He is doing everything arbitrarily. If a one bureaucrat can do everything arbitrarily, and
Right.
Tushar Mehta goes on, no,
Right.
let me complete. Let me complete on. This is totally wrong. This is a political issue. We are trying, we beggars, with due regard to the legal luminaries here, I will say, we are not beggars. It's wrong. Beggars cannot choose. Are we going to the court as beggars? We are pleading in a logical manner, in a legal manner, but we are not beggars. I differ on this issue. We are the citizens of the country. As the honorable bench is there, as per the constitution, we have the same right, the legal luminaries have to plead the case on facts. So it is not a question of beggar or giver. No. We say my lords, but they are not the gods.
No, no, that
They are
is not what
human
I
beings.
was saying. The only thing being that the direction the court is taking, we have to
Whatever it is.
eventually
Whatever it
get
is.
what we can get out of
I
the, we need, at the
agreed.
end of the day,
Agreed.
we need an order
Agreed.
which
Agreed.
can help
Sure.
people.
Whatever it is.
Yes.
Let me just with due regard. On the first day also we heard the one of the politicians saying, we have got a good order, we have done this. We are trying to find out positivities in the orders. I say, and you will see it will happen that they are trying to, the Home Minister is trying to introduce NRCCA through a bureaucrat because politically they were unable to do it. And the Honorable Supreme Court is one way or the other way siding with them on this issue. So, no, who says that the citizenship should not be decided? Who says, who is any one person in India except the foreigners who are trying to get a order right to vote? Who is there to say that foreigners should be allowed? Nobody says. Who said that that should be there in the list? Who said that those who are not the ordinary resident, but the everything is to be done as per law? We are not doing. Who says? Oh my Lord, the Burmese will come, the Bangladeshi. This is the Supreme Court, and in the pleadings in the Supreme Court are like I will again say like a panchayat, not on the law. Now, if the commission says that they are trying to, did the commission find the foreigners? How many foreigners did they find? 7.24 crore. They say we have taken the farms, we have included, we have uploaded the farms. In 7.24, did they find? In 65 lakh, they have removed. Did they find? Have they removed any? Even one single that it was.
That's
Why do you raise this question? It is just like the election commissioner asking Rahul Gandhi when he says 1 lakh and 250 votes have been changed, increased, fudged in one constituency, assembly constituency of a PC. They say you give affidavit about one voter whether she voted twice or not. Baba, you are the commissioner. You should see whether it is not whether the same lady has voted. You have the records. You have form number 17A. You see whether against that vote has it been voted or not. Because you have the list. We don't have the. Then
Right.
first you check. So the way the things are going on, Nidu. Why I am very much agitated. Also, frankly speaking, I'm not speaking normally today. I'm so much agitated. We don't do like that. Our country was not like that.
Hmm.
Now, this is a political issue. No,
Right.
no, no, one line only I will say. This is a political issue. The, the citizenship of the country, of the minorities, of the ruralites, of the poor, for which there was a discussion in the Constituent Assembly. One Article 324, 5, 6, 7 were introduced. In the Constituent Assembly, there was a we should not give voting right to the woman. We should not give it to the illiterate. We should not give it to the, you can say, the ruralites and all that. Uh, there was discussion. Our forefathers did not agree to that. And it was decided. No, like one Ganesh Kumar who has never fought, might be his elders might have not fought the freedom movement. And he is trying to upset the whole apple cart, which we have settled by so many sacrifices. If at all something is to be made out in the Supreme Court we have to make out whether we are to keep this democracy or not. Let the court decide. Let the court say that it will be autocracy. Let the court say it will be a dictatorship. Now, once you withdraw, who says that a person who is dead, who should be? But Ganesh Kumar has entered. Has he any answer? We are trying to defend. They are trying to offend. Court does not ask them, okay, punish those, the CEO of Bihar who has compelled the BLO. We ultimately got to punish the BLO. Who is BLO? BLO is a poor guy. It is the it is the CEO of Bihar and it is the ECI Ganesh Kumar and the Trimurti. They are responsible for whole this mess. They have entered the names of those, not only one, two, tens, hundreds, thousands of the names, maybe even
Right.
in lakhs. They have entered the names of dead people in the list. They are
Okay.
themselves. They have
Right.
entered the names, duplicate names. Again, Bayer has given so many articles and that. The Supreme
Right.
Court is not questioning all these things. This is not an
Right.
SIR. This is
You're right.
one line. This is an exercise to snatch the right of voting right of the people, and the Supreme Court exercise is going to help Ganesh Kumar to do that.
I'll come to Neha now for the last question. As a lawyer who's fighting this SIR case, since so many violations and transgressions have happened in the past, what are the challenges now you see on the ground in Bihar, especially after today's directions that Aadhaar should be made the 12th document now? Now, like earlier times, they had sent show cause notices to the BLOs. On the ground, the things were not working. What are the challenges now you're expecting, especially after today's order? And how will you ensure that things do take place and are carried out properly on the ground?
Neelu, the order has not been uploaded as yet. So we need to see. But as orally they had mentioned that this should be publicized by the ECI. Now, the problem that the people are going to face is one thing is that enumeration form phase is anyway over. So everybody now, if their names are deleted, have to go through that process of claims to get their name. Now, not only is this an inconvenience, but this was absolutely avoidable to go through a process again. So that deadline also needs to be extended of when people you could give their enumeration form, because at that time people might have given they did not accept immediately. So for 1 month many people got left out just on this basis. So that needs to be rectified. Of course, a larger battle is there with regard to the notice hearings that are going to take place. These notices are absolutely again illegal. They do not even mention under which provision of law these notices are being issued.
Yes.
They do not mention what is the exact discrepancy that is found. They say you come within 7 days and bring original your documents that you gave. No acknowledgement was given. I don't know what is the discrepancy, but I have to attend that hearing. People might not be over there. in Bihar at that time. So that also needs to be, technically extended. Also, then there is the issue of appeals. So first appeal before the DM against the speaking order in the notice hearing. First appeal to the DM, second appeal to the CEO. There is hardly any, time for that. So there are a number of things of the interim nature that we are going to press on Monday. Of course, repeating our prayer with regard to you. Hear the main issue. Hear the main issue. Legality has to be decided first. But whatever it is, we will press for other things that could go wrong. We also need to closely monitor now whether Aadhaar, anybody is raising, issue with regard to Aadhaar, and whether or not this is publicized. Properly. One good thing might come out of this, of course, because the order was not only for Bihar. The SIR order was categorically for the entire country. So now that they issue any communication from the CEC to the CEO of any state, so they need to make sure, because that would be a very strong argument on our part. You accepted it for Bihar, you need to accept Aadhaar as the 12th document
Right.
for this thing also. But of course, our fight for the constitution, that this is unconstitutional, of course, continues. But challenges remain as and when the issues come up. We need to bring them to the court's notice.
Right. So
You know,
challenges
I
are,
want to say one thing,
yes,
only
Dr.
one line.
Patel, very briefly. Ha, yes. Tell me.
I just want to say that there is a provision now because we are in the end of the procedure. There is a provision, the legal dominions must have read it. If the revision of the electoral rolls is not done properly, the Election Commission is authorized under the People's Representation Act 1950, Section 21, that the earlier rolls are to be used. So far, Bihar, there should be an effort to take an order from the Supreme Court, okay, my lord, let this Bihar election be conducted so that we are not hampered from deciding the issue at large. We are not facing a time constraint. We get this order, whether we are successful or not, it is a different issue. But if we try to get it and agitate over it, that let the revision which was done on 1st January 2025, let that be used for the Bihar election so that there is no pressure of time for the SIR to be conducted properly.
Absolutely. So the next hearing now is next Monday. So we'll have to wait and watch what Supreme Court says. But as of now, the directions have been given to make Aadhaar as the 12th document, which is going to be acceptable. But the billion-dollar question remains: will uh, Election Commission of India obey the orders? What is going to be the situation on the ground? Will the BLOs again listen to the voters when they carry their enumeration forms? These are questions which need answers, and also all eyes would be stuck now on what's going to happen in the coming days. Thank you so much, Neha Rathi, Dr. Pyare Lalgar. Thank you very much for joining on the Federal. Thank you.
Thank you.